Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Well, welcome to another episode of Estates Made Simple. And today we get to have a discussion with regard to what about small estates and do you need to go through the probate process for that? So welcome, Jenna. Nice to be podcasting again with you on this topic as we explore the world of making estates simple.
Hi, Gord. Yeah, nice to chat with you. I love all of our discussions and being able to educate the executor when they're doing their job.
So hopefully if you're the executor of an estate, it would be a situation where the person has accumulated enough wealth during their lifetime that they've been able to support themselves and leave a financial legacy to their loved ones, right? And that's, I think, the plan for most of us, especially if you have children, you go, I want to leave something for my children or grandchildren. If I don't have children, there's favorite causes or other extended family I want to leave a legacy to with regard to what I don't spend in my lifetime. But sometimes there's situations where the estate is a little bit smaller. And one of the questions that an executor may have is, well, I hear this probate process is a four-letter word, and I read on the internet I'm supposed to try to avoid this. So we wanted to explore today a little bit about, well, what's involved, and particularly it's usually the larger the estate, it's almost certain you have to go through that process. So it's not really a decision making. But on smaller estates, sometimes there's some options or at least a different set of parameters to think through about whether you go through that. So we want to explore that a little bit in today's podcast. So in general, we can start with the proposition that in most cases, as I've alluded to, probate is going to be required. I don't know, as the lawyer who does this work, I think there's a bunch of advantages associated with probate, and we've talked about that in other episodes. In some cases, and usually it's because if you're trying to deal with the assets, the people you're communicating with require that you prove you are the legal representative of the estate, and that grant of probate, that court order is what gives you that authority, right? So now you can deal with the banks, you can deal with land titles, you can deal with Canada Revenue Agency, you can deal with anybody who is questioning your authority because the court has given it to you. You have a court order that lays that out. But in a situation where maybe it's not a big estate, it's a relevant question to say, well, do you need to go through the probate process? So as a general rule of thumb, it's hard to say there's not an exact rule on this because it does depend on who you deal with. So typical lawyer answer, depends. But certainly I think our experiences are similar that if you get estates that are kind of above that $30,000 to $50,000, almost inevitably, some other third party is going to be asking for that grant of probate. Prove your authority. I want to see that before I take instructions from you. So it'd be very hard to convince those third parties, if it was $300,000 or $500,000 to say avoid probate. But on smaller estates, I mean, bank managers and other parties are cognizant to say, well, if I can avoid that cost, then maybe that's something worth exploring. So you might be able to convince the local bank manager to say, well, can you just transfer it into my name? So it depends also, this is where the size of the estate does matter, that if we're talking a smaller amount, it's not lost, I think, on the banking employees, the managers, people making decisions to say, well, if I force them through this process, assuming they have to get help to do this, and they're going to go to a lawyer and it's going to be X number of dollars to do that. If that becomes a pretty disproportionately high value of the estate, then maybe they can exercise some discretion, right? And the probate is really there for protection of these third parties, that they know who they're dealing with, right? And that we make sure whatever the last will is the last will, because if they just assume and not rely on the probate process, maybe they're in a situation where there's a problem. And maybe we can give an example of that. Let's say there's $100,000 in a bank account, and there's a will that left a nephew as the executor and everything to the nephew, and it was like a 10-year-old will. Well, the nephew after the funeral finds that will, or maybe is holding it, and goes to the bank and says, here, it's all coming to me. I'm the executor. Can you give the money to me? Well, let's say the bank does that and writes the check to the $100,000 to the nephew. Well, then a week later, the niece shows up and there's a will that was made a year ago. So revoking the 10-year-old will, that leaves the niece as the executor and everything to the niece. So the niece shows up and then the bank goes, oh, sorry, we gave it all to your sibling. And now there's nothing there. Well, guess what? The bank's going to get sued in that case, right? Because they assumed that the nephew had proper authority and that the nephew was demonstrating and putting forward to the bank the most recent will in time. So, and even if the nephew did that innocently, not trying to deceive anybody, they had no knowledge of this other will. The testator didn't share it with them, just shared it with the niece, right? Say, well, I've done a new will, here's a copy, you hold on to it, right? So now you could see this situation where the bank's now in a bind, which is kind of, I thought it was an interesting example to help illustrate, well, why are the banks so difficult in asking people to go through the probate process? Because they don't want to get sued. And how do they know what the last will is? The probate process confirms all that, right? And it allows through that, to adjudicate who the right person is with regard to that. The other thoughts with regard to getting into this topic would be, if you decide that you don't need to go through the probate process, it's not a requirement for you to successfully complete the administration of the estate, then in that case, there may be circumstances under which you still have to give notices, right? So there's forms that are called non-grant application forms. So if you don't go through the probate process, you may still have to notify a family member who has a claim, a surviving spouse or partner who has a claim, or if there's a notice that has to go to the public trustee because there's a minor involved, or they're managing funds for a represented adult. Those are notices that would go out through the probate process. But if you don't go through the probate process, you may still have to give those notices that people would have a claim against the estate. So just be aware of that if you reach the conclusion that you don't have to go through, you want definitely some advice to say, do I have to give notice to anybody? Because if you don't, there may be some liability associated with you failed to notify them that they had a claim. And if you distribute without giving that notice, then they maybe can come back on you for not doing that properly.
And that would not be good.
That would not be good.
Not at all. In terms of what types of assets you'll need probate for, so real property in the deceased's name alone, as well as those financial assets, as you mentioned. But an executor may also decide to go through the probate process, even if they don't necessarily need to. And one reason you may wish to go through the probate process is if you're anticipating getting a claim against the estate. So when you obtain the grant of probate, there's a limitation period that starts of 6 months for any potential dependents to file a claim against the estate asking for more money or money in general. So the probate process really starts that limitation period. Without probate, there's ambiguity of when that process starts. And so it's really good to go through that if you're anticipating any claims, and just protect your liability from an executor perspective. After that 6-month limitation period passes, then you're able to distribute assets to the beneficiaries listed in the will without risk of putting yourself under liability for dispersing those assets too early.
And it does facilitate the timely administration of the estate, because if a general limitation period in Alberta is 2 years, in some specific situation, it might be a different time period, but let's just start with that sort of general principle. If you go, well, I want to wrap up this estate in the executor's year, and we've talked about that in other podcasts, by rights, you'd have to wait for that 2-year limitation period to expire before you distribute any assets. So most people like the idea of, if I go through the probate process, I can wrap up this estate quicker. So it's really protection for the executor. So it can, as you pointed out, be a really good thing. And not only, as I talked about, helps you deal with third parties and people know you are the right person. You have the legal authority to administer those assets, but it's protection there from a liability perspective. Because if you distribute and you didn't properly deal with people who had claims against the estate, they may still be around a number of years after the person passed away, right? And you go, well, it's all distributed. If there's nothing in the estate, guess what they're going to do? They're going to go, well, then you better pay. And now it's coming out of your pocket, right? So just be aware of that. I think that's an excellent point to say. I think it's a good question to ask is, do I need to go through probate? And then the follow-up to that, as you've alluded to, is, well, do I want to go through probate? Like maybe you want to opt in and say, well, I do want it because I want to trigger a limitation period, would be one example. Or I don't want people to challenge my authority. And then you buy into the whole set of rules associated with resolving that estate and clarity about that, right? So that, you still have to administer, you still have to discharge your responsibilities, but sometimes people like the comfort of, well, we have a system, we have rules. We were going to go through the normal system, and then that feels better than trying to avoid that application process may, in the end, not really be a savings of money. And as you're pointing out, putting risk on yourself as the executor when you don't need to.
Right. Well, and I really like the probate process. I know that sounds weird, but it does give you a starting point of what assets you need to deal with. And it gives notice to the beneficiaries, all the information that you have as an executor. So I think it's a positive thing in many ways to have a starting point, keep you accountable, have the beneficiaries accounted to, and just start the process of the estate administration in a timely fashion, as you mentioned as well.
And oftentimes people, let's use an example of vehicles, because what I often hear is, well, okay, the probate process is going to take a little bit of time. Interesting note, the latest report, we're recording this in March of 2024, so it's time sensitive, from the courts is that with the new surrogate digital process, their turnaround time is 14 days on average. Some are longer, but probate used to take months and months and months, and it's much expedited. So that is a good thing. I think takes a little bit of the negative reputation off of that probate process. But sometimes people say, well, okay, but I've got this car, it's sitting there. What do I do with the car? Assuming, we got to go through this process and before I can sell it. And in Alberta, and it may be different in different provinces, so check your local rules, is that oftentimes the registries here will not require that court order, that grant of probate. If you show up and you fill out the bill of sale that it's going from the estate of the deceased person to the beneficiary, they will generally accept it. They might ask for a death certificate, but if there is no probate, you say, well, we didn't have to go through it. They will accept that you're telling them the truth and feeling that you have the authority to actually sign on behalf of the estate. So, I mean, quite frankly, somebody filling that out should be careful to make sure they actually have the authority, because what if that's challenged and it turns out they're not the executor? Oh, that's the example of the nephew running off and dealing with the car in my earlier example. Well, it may turn out that he's not the executor, but he thought he was, right? So, have some caution on that. In most cases, it's pretty clear who the executor is, and it's not an issue. But you should be able to deal with the registry, which actually is prudent, because if it's an asset that would otherwise, needs to be maintained, it's a depreciating asset, the sooner you can deal with that, the better, right? So if there's no other red flags about whether you should be doing that, you may not need the probate process. In many times, I'll encourage clients to say, try to deal with the registry, and most of the time they're successful on that in that process.
Well, and another example of a common question that we get is, do you need probate to transfer privately held corporation shares? And the answer is typically no, you do not. You can retain a lawyer to draft the documents. If you're selling it, obviously you need to go through that process, but you don't need probate to transfer those shares, which is a good thing if you need to transfer them on an expedited basis.
Yeah, interesting fact situation. I've only had one circumstance where that didn't happen. And that was, we're dealing with shares in a company, but it dealt with a marina in BC. And they required the resealing of the grant. In fact, that was a grant application, but we were trying to see if we could avoid going through probate in BC. And it turned out we had to. The only reason I never got a straight answer, but I think the reason is it's probably federally regulated, because it's a marina and they required proof that that was the right person, and something under BC law to provide, the marina said, no, our lawyers say we need it. So there are some exceptions to the rule. They're very rare. For the most part, you can pass a director's resolution and go through it. The other scenario would be if you're in the middle of selling the shares of the company and the purchasers wanting proof that you have the authority to give them the shares. I suppose they could say, well, we want to see the grant of probate. And it might be, that's an example where you might want to opt in because it would be one less thing to create an issue on the transfer of those shares to a purchaser if the company is going to be sold. So you say, well, just out of an abundance of caution, I don't want this to come up. Let me opt in and get it, even if I don't need it. But I agree wholeheartedly with what you said, which is if the only asset in the estate is shares of the company, I wouldn't be recommending in the normal course going through the probate process for that asset. Again, we go back to your earlier comment of, well, maybe there's other reasons you want to go through it other than transferring the shares, but you should be able to step in and control those shares. And then as shareholder, then the executor of the estate could appoint themselves as directors and then appoint as officers to be able to control, change the signing authority at the bank. Now they're controlling the bank assets and any corporate assets and be able to administer those business assets in the ordinary course on that. So yeah, good comment on that. And the other thing to consider with the probate, I guess we talk about it being a good thing, but in some provinces, there's some extra costs associated in terms of what a local government is going to charge. What's the scenario in Alberta?
Yes, and Alberta is actually a really great place to die. I know we've mentioned that previously, but probate costs in Alberta a maximum of $525. So it's really not a large expense for the estate with all of the protections that you may get in place by going through that process. And then another interesting fact about probate is that once a will is probated, it becomes public record unless the court decides to seal it for a certain purpose. But generally speaking, the will becomes a public record and anyone can go and apply to obtain a copy and read it and all of the family secrets, of course. But that's something that many people don't know and should be aware of.
Indeed, and even for small estates, which is certainly some of the stuff we're talking about, there's even lesser amounts. There's a range in Alberta between $35 and the $525 you mentioned. So if we're dealing with a small estate, it may even be less than that amount. So that sort of helps in terms of deferring costs or reducing costs and making it easier to kind of go through that probate process and gain the advantages of going through that. But something certainly to get some advice on and make some decisions. So good conversation with regard to that. Again, as we talk about in other podcasts, there's not a one size fits all. You do have to look at the circumstances of each estate and make a responsible decision, including, what do you do if there's limited funds, right? And I think even more so if there's limited funds, if you're going to be incurring expenses, you want to make sure it's absolutely necessary, right? And because, people may say, well, why did you do that? So it is something you don't want to be flippant about. You want to put some good thought to, but a good conversation. So I want to thank you, Jenna, for the conversation and encourage all our listeners and viewers to continue to subscribe, whether that's in any platform that you listen to podcasts or on YouTube, and reach out to us. We'd love to engage in a conversation with other topics you want, or if there's questions arising out of this situation, you can reach out to either one of us, and we'll be happy to either answer the question or direct you to a source where you can get the answer to your questions, because we're here to make that estate administration simpler, to not only in our explanation, but if we can steer you in the right direction, we'd love to be able to do that. So thank you for listening. We appreciate the time that you've given. Hopefully you found this episode to be of benefit, and we'll wish you well until the next time we hit the record button together, Jenna.
Sounds great. Take care.